Something just cracked open in the Second Amendment fight, and the silence around it is loud enough to be a warning siren. A thing happened, documented, formal, federal. And if you've spent any time paying attention to how constitutional rights actually get defended in America, you know why this matters. Because for decades, the pattern has been predictable. States pass restrictions, gun owners absorb the damage immediately, and then everyone waits years for the courts to catch up. That's been the rhythm. That's been the trap. That's been the game. What's different about this moment is not another lawsuit filed after the fact. It's not another organization announcing a challenge once the law is already hurting people. It's not the usual slow grind of, see you in 5 years. It's the federal government stepping in early, before the harm, using the language and posture of civil rights enforcement, not political commentary, not vague statements, not, we're monitoring the situation, but a clear warning that unconstitutional restrictions will trigger immediate federal action. And if you live in a state that has spent the last decade stacking restrictions on top of restrictions, if you live in New Jersey, New York, California, Illinois, Maryland, Massachusetts, or any state where the Second Amendment is treated like a privilege you rent from the government, this is the kind of development that should make you stop what you're doing and pay attention. Because the method matters as much as the outcome. Strategy changes the timeline. Strategy changes the cost. Strategy changes whether rights are protected in real time or only after they've been violated for years. One important note before we go further. I'm going to talk about this in the way an accountability explainer should be handled, focused on what is reported, what is documented, what it would mean if enforced, and what the limitations are. This is not personal legal advice. It's not a permission slip to do anything. It's a breakdown of a shift in posture that, if sustained, can change how fast unconstitutional laws get stopped. Now, to understand why this is so unusual, you have to understand the old playbook. And it really was a playbook. It wasn't accidental. It wasn't well-intentioned lawmakers making mistakes. It was a strategic system designed around timing. Here's how the game has worked for as long as most gun owners can remember. A state legislature, usually in a heavily restrictive state, passes a sweeping gun restriction. It might be a rifle ban. It might be a magazine capacity limit. It might be a permit scheme that functions like a gatekeeping system. It might be an expansion of prohibited places so broad that your permit is technically valid but practically useless. It might be a fee and training labyrinth that turns a right into a series of hurdles designed to discourage normal people. Does it matter on the day that law is signed, whether it is constitutional? Not in practice, because the moment it takes effect, it becomes enforceable. It becomes something you can be arrested for violating. Gun stores have to comply immediately. People who already own the now restricted items have to make decisions immediately. Register, modify, surrender, or become criminals on paper. People who had a lawful path yesterday suddenly don't have one today. The harm hits on day one. But the challenge doesn't. The legal challenge takes time, real time, expensive time, years. You need plaintiffs willing to be named. You need attorneys willing to fight a complex constitutional case. You need money. You need patience. You file in federal district court. You request an injunction, and you often face an extremely high bar at the preliminary stage. You appeal, you wait, you get a stay, you wait more, you get a circuit decision, you wait more. If the circuit gets it wrong, you wait for the Supreme Court to decide whether it wants to take the case. And while everyone waits, the law keeps doing its work. The law keeps burdening people. The law keeps changing behavior. The law keeps pushing businesses out. The law keeps making ordinary people risk-averse. It keeps forcing compliance under threat of criminal penalties. That time asymmetry is the heart of the strategy. Legislators got political credit today and legal consequences 5 years from now. Even if the law eventually got struck down, the cycle still worked because the political reward was immediate and the constitutional correction was delayed. Some of these laws were likely passed even with the understanding that they might not survive forever, because the survival wasn't the only point. The point was the years of enforcement in the meantime. The point was the deterrence. The point was the chilling effect. The point was forcing people into the narrow behavioral lane the state preferred. This is what people mean when they say they don't care if it's unconstitutional. They care that it functions long enough to reshape reality while the courts move slowly. So now, look at what changes if the timeline changes. Look at what changes if the moment a state moves to pass a clearly vulnerable set of restrictions. The federal government steps in and says, if you enact this, we will sue immediately and seek to block enforcement before your citizens ever have to live under it. That is a different game. That is a different risk calculus. That's no longer political reward now, legal fight later. That becomes political reward now, federal lawsuit now. And for a subset of legislators, especially the ones who vote for restrictions because it's politically fashionable, not because they want to spend years defending it in high-profile litigation, that shift matters. Now, here's the reported development that triggered all of this. A formal communication from the Civil Rights Division of the Department of Justice, again, not a random office, not a casual statement, put the state of Virginia on notice regarding a slate of proposed gun restrictions moving through the legislature. Proposed, not yet enacted, not yet signed, not yet enforced. That's the key detail. It was pre-enforcement. Instead of waiting for passage and then reacting, the DOJ signaled it was prepared to bring suit and seek injunctive relief if enacted, meaning the goal is to stop enforcement before the law gets the chance to harm people in the first place. If you've followed this space for years, you know why that's rare. The federal government has not consistently treated Second Amendment burdens the way it has treated other civil rights burdens in terms of proactive posture. Historically, the burden has fallen on individuals and private organizations to litigate, to fund lawsuits, to carry the timeline. This is why the choice of the Civil Rights Division matters. It isn't just bureaucratic routing. It is a framing statement. It treats the Second Amendment not as a policy controversy, but as a civil right requiring proactive protection against state overreach. And the moment you frame it as civil rights enforcement, the strategy changes, not only in court, but in politics. Because if a state legislature passes a law and the next headline is federal government sues state for violating the constitutional rights of its citizens, that is a different story than state bravely passes common sense law, faces challenge from gun lobby. It flips the narrative. It flips who is on offense. It flips who has to justify themselves. Now let's talk about the constitutional foundation that makes a posture like this plausible, because none of this matters if the underlying legal framework is weak. The federal government can posture all day, but courts decide outcomes. And the reason this moment is happening now, and not 15 years ago, is because the Second Amendment framework is stronger today than it has been in modern history. You can trace that framework through three major Supreme Court decisions that form the bedrock. First, District of Columbia versus Heller in 2008. That case clarified that the Second Amendment protects an individual's right to keep and bear arms for lawful purposes, particularly self-defense, and that it is not limited to militia service. That was foundational because for years, courts had treated the Second Amendment as if it were collective and functionally optional for civilians. Second, McDonald versus Chicago in 2010. That applied the Heller-recognized right against state and local governments through the 14th Amendment. This mattered because most gun regulation happens at the state and local level. Without incorporation, states could have continued to treat the right as something that binds Washington but not Springfield or Trenton or Sacramento. Third, New York State Rifle and Pistol Association versus Bruen in 2022. Bruen did two major things. It struck down New York's discretionary may-issue carry regime, systems that required ordinary citizens to prove proper cause or special need. But arguably more important, it changed the test courts use to evaluate gun restrictions. It rejected interest-balancing approaches and emphasized a text and history framework. The government can't simply say public safety and win. It must show the restriction fits within the historical tradition of firearm regulation. That shift matters because it raises the burden on governments defending modern restrictions that have no historical analog. It also limits the ability of lower courts to uphold restrictions through vague balancing tests. It changes the default posture from the government's policy preferences deserve deference to the government must justify burdens on a right through a historically rooted framework. Now, add another important concept that runs through modern Second Amendment jurisprudence: common use. If a firearm is in common use by law-abiding citizens for lawful purposes, the constitutional protection argument becomes much stronger. And this is exactly why bans on widely owned firearms face such heavy legal pressure. It's why bans and restrictions on commonly owned rifles, magazines, and standard equipment have become central battlefield issues. That's not a political statement, it's a doctrinal reality. And it's why the legal environment is more favorable to challenges today than it was when states were writing and defending restrictions under looser standards. So now, if you are a state government considering a new restriction in 2026, you're not operating in 2016. You're operating post-Bruen, under a more demanding legal environment, with a stronger constitutional foundation. That alone changes litigation outcomes over time. But what happens if you add federal pre-enforcement posture to that? What happens if the DOJ begins treating certain categories of proposed restrictions as civil rights violations that merit immediate federal response? Now the timeline changes. Now the cost structure changes. Now the burden of litigation shifts. Now the state can't count on years of enforcement while lawsuits crawl upward. Not if injunctions are sought immediately and aggressively, and not if federal resources are behind the case. This is where the implications for heavily restrictive states become clear. Because a state like New Jersey, for example, already has many of the features that have been most contested post-Bruen: bans, capacity limits, broad sensitive place maps, expensive and layered permitting systems, and regulations that push up against the boundaries of what courts are willing to uphold under historical tests. And yes, much of this is already being litigated. There have been injunctions in some areas, appeals, stays, further litigation. The momentum is real, but it's moving at the pace of federal courts, which is not fast in human time. So the question becomes, if the DOJ truly adopts a posture of proactive enforcement, does that accelerate the timeline and change the dynamics in states like New Jersey? The honest answer is, it could if followed through, because posture without action is just rhetoric. But action, actual lawsuits, actual injunction requests, actual federal follow-through, changes everything. It changes the resource imbalance. States have enormous legal resources because they are funded by taxes. Private organizations and private plaintiffs do not. When the federal government steps in, the who can afford to fight problem looks different. It changes the signal to courts. Courts treat federal enforcement actions differently than private ideological lawsuits. Not because judges are supposed to be political, but because the posture and seriousness of the action changes the tone and urgency. Federal involvement can influence how quickly cases move and how aggressively injunctions are considered. It changes the political optics. Gun group sues state is a familiar headline that state officials have learned to spin. DOJ Civil Rights Division sues state for violating constitutional rights is a different headline. It creates a different kind of accountability pressure. Now, here's what people need to understand about the political machinery behind many state restrictions, because this is the part that often gets ignored. For years, legislators in certain states have been able to vote for restrictions with a very comfortable form of impunity. The political benefit is immediate. They get to say they did something, they get applause, they get the press conference, they get the fundraising email, and if the law gets challenged, they get to pivot. We're fighting the gun lobby in court. Donate to help us defend this law. The legal challenge was baked into the political strategy. They weren't necessarily expecting every restriction to survive forever. They were expecting the challenge to be slow enough that the law would function for years anyway. They were expecting the litigation to be someone else's problem on someone else's timeline. If the federal government starts moving immediately against proposed restrictions, the strategy changes. The legal cost becomes immediate. The political risk becomes immediate, and the lawmakers who were voting for restrictions as performative politics might hesitate when they realize the fight is no longer years away. Now, to be honest, not everyone hesitates. In deep blue states, the political incentives for restriction are very real. Primary threats are real. For some politicians, being sued by the federal government might even be framed as a badge of honor. Some will lean in harder. But there is a group of lawmakers, especially the ones who are less ideologically committed and more politically opportunistic, who are comfortable passing symbolic restrictions because the consequences are distant. For those lawmakers, immediate federal action changes the calculus. Even if only a few votes change, that can affect whether certain laws pass, how extreme they are, and whether they are crafted more carefully. And that matters because the best constitutional win isn't 5 years later in an appellate decision. The best win is fewer unconstitutional laws being enacted in the first place. Now, let's talk about what this means for gun owners, because it's easy to get lost in court strategy and forget the practical. The practical is that most gun owners live under a patchwork of rules that change constantly. That patchwork is not only confusing, it's dangerous. Not dangerous in a cultural sense. Dangerous in a legal sense, because the typical law-abiding person does not have time to track every legislative session, every emergency bill, every injunction, every stay, every appeal. People work jobs, they raise families, they live life, and the law can change while they're doing normal life. When a state changes a rule about what magazine is legal, what rifle is legal, where you can carry, what training is required, what signage is required, what constitutes lawful transport, and those rules change quickly, ordinary people can fall out of compliance without realizing it. And state governments have benefited from that confusion. Confusion discourages exercise. Confusion creates fear. Confusion makes people decide it's not worth it. Confusion makes people either give up or accidentally violate something. So a federal posture that pressures states not to enact new layers of restriction matters not only as a political story, but as a safety story for ordinary law-abiding people trying to stay legal. Now, I want to be careful about not turning this into a fantasy where the federal government suddenly swoops in and fixes everything. That is not how it works. Even in this scenario, there are limits and risks. First, lawsuits still take time. Even if filed quickly, litigation is not instant. Courts have procedures. Injunction standards still apply. Appeals still exist. Second, judges still decide outcomes. A federal lawsuit does not guarantee a win. It increases resources and urgency, but courts can still rule incorrectly. Courts can still stay injunctions. Circuit courts can still interpret standards in ways that force cases back to the Supreme Court. Third, states will not stop. They will adapt. They will rename restrictions. They will create objective requirements so burdensome that they function like barriers. They will expand sensitive places. They will use administrative delay as a policy tool while claiming it is a processing necessity. They will try to rebuild walls with different bricks and dare the courts to knock them down again. This is not pessimism. This is realism. Governments do not surrender power quietly. They transform their methods. Now, let's talk about what a state workaround strategy typically looks like, because this is exactly what gun owners need to watch for. If a state is warned that it cannot impose a direct discretionary ban, it may shift to process burdens. It may say, "We're not banning anything, we're just requiring training." But that training is offered only in limited locations, only at limited times, and it creates weeks of delay. If a state is warned that it cannot impose a waiting period beyond verification, it may redefine verification. It may attach new screening steps that conveniently take 7 to 10 days and claim they are necessary for public safety. If a state is warned about may issue discretion, it may keep shall issue in name, but create long lists of conditions that increase cost, increase bureaucracy, and create processing delays that function like a denial for many people. If a state is warned that it can't ban carry broadly, it may expand sensitive places so widely that carry becomes practically impossible in daily life. This is how rights get restricted in practice, even when courts strike down direct forms of restriction. It becomes about friction, delay, cost, complexity, geographic traps. So if the DOJ truly is shifting posture toward proactive enforcement, the next question is, does it also challenge the workarounds? Because in the real world, the workarounds are where the fight moves. A state can comply on paper and resist in practice. Courts will ultimately decide whether that resistance is lawful, but until courts do, the workarounds can function. This is why the significance of a DOJ warning is not in the warning itself. It's in what follows. Does the federal government file? Does it seek an injunction? Does it move fast? Does it intervene in other states? Does it treat Second Amendment burdens as civil rights enforcement consistently, or does it do it once and then retreat? Because one action can be symbolic. Repeated action becomes policy, and repeated policy becomes a new reality. Now let's step back and understand how this would affect the legislative behavior in restrictive states, because this is where the long-term consequences become bigger than Virginia or any one state. For decades, the political strategy worked because the litigation lag was a feature, not a bug. The state could impose restrictions, claim victory, enforce them for years, and then, if the law was struck down later, they could blame activist judges and move on. If federal action makes the lag shorter, if the enforcement window shrinks, then the value of passing unconstitutional laws drops. The political benefit is still there, but the legal cost becomes immediate and visible. It becomes a short-cycle fight that is harder to manage politically. Also, it shifts who bears the cost of defense. If the DOJ sues, the state's defense becomes a headline, a budget item, a public fight. And if the state loses quickly, if injunctions block enforcement early, the political narrative becomes less triumphant and more embarrassing. We passed a law we couldn't defend. Some lawmakers will not care, but some will, and that matters at the margins. Now let me be honest about the limits again, because clarity matters. Even if federal intervention accelerates certain cases, it does not automatically dissolve existing restrictive frameworks overnight. States like New Jersey and California have entire ecosystems of restrictions, many already being litigated. A DOJ posture might accelerate certain categories, but the overall structure will still take time to unwind. This is not a light switch. It's a series of battles. The significance here is not everything is fixed. The significance is momentum and strategy. Momentum matters. Strategy matters because constitutional rights are not protected by good intentions. They are protected by enforcement. And enforcement changes when the federal government stops being a spectator. Now, if you're a gun owner hearing all this, you might be asking, okay, what do I do with this? What does it change for me tomorrow? Here's the responsible answer. It does not change your day-to-day legal obligations until the law changes in your jurisdiction. It is not a permission slip. It is not a defense if you violate existing law. It is not a substitute for knowing your state's rules. What it changes is the trajectory. It changes the likelihood that new restrictions will be blocked faster. It changes the likelihood that certain proposed laws will face immediate challenge instead of years later challenge. It changes the sense of whether your rights are being treated as civil rights worthy of proactive protection or as political issues you have to fight alone. But your job as an individual remains the same. Stay current on the law where you live and where you carry. Don't assume. Don't rely on social media summaries. Don't act on someone said it changed. Verify through credible sources. Because even in the best-case scenario, the period when laws are shifting is the period when people get arrested for not understanding what is actually enforceable today. Now, let's talk about what it means if the DOJ truly is building a template. If the federal government issues a warning to one state about a category of restrictions and then follows through with litigation, that becomes a blueprint. It signals to other states that the same category will be targeted elsewhere. It also signals to attorneys general in restrictive states that the federal government may join fights that were previously left to private litigants. That ripple effect matters because constitutional litigation is often about patterns. If a federal agency adopts a consistent strategy, it doesn't stay localized. It becomes a national posture. And that's why this matters beyond Virginia. Because the Second Amendment fights in America do not stay inside state borders. Legal reasoning spreads. Court decisions spread. Litigation strategies spread. A win in one state becomes a weapon in another. A warning in one state becomes a template for another. Now let's close with something that is both optimistic and realistic. Optimistic. If the federal government genuinely begins treating Second Amendment burdens as civil rights violations that warrant proactive enforcement, that is a big shift. It changes incentives. It changes timelines. It changes who bears the burden of defense. It tells ordinary gun owners that they may not be alone in funding and fighting every battle after the damage is already done. It is a structural change, not just a rhetorical one. Realistic. Nothing is automatic. Nothing is guaranteed. The courts still decide, states still resist, workarounds still appear, injunctions can be stayed, cases can drag. And if federal posture fades into inaction, then it becomes a footnote instead of a turning point. So the only intellectually honest way to describe this moment is as a potential inflection point, a shift in momentum, a change in strategy, not the end of the fight. If you care about how this plays out, watch what happens next. Watch whether the DOJ follows through with filings. Watch whether injunctions are sought. Watch how quickly courts move. Watch whether this posture expands to other states with similar proposed restrictions. Watch whether it becomes consistent policy or one-time posturing. Because this isn't background noise. This is the machinery that determines whether rights exist only in theory or exist in practice. And the practical reality is that the next several years of litigation and enforcement decisions will shape the legal landscape for a generation. Not because one letter solves everything, but because strategy, especially federal strategy, changes the speed at which unconstitutional burdens get stopped. Stay sharp, stay informed, stay engaged, and don't let anyone convince you that the only way rights get defended is by waiting quietly for 5 years while the damage accrues. If the federal government is truly shifting toward proactive enforcement, that's a door opening. Whether it stays open depends on what happens next.